Hello and welcome to the first in a series of podcasts from Employee Management, dealing with recent developments in employment law. My name is Chris Nagel and I head up the HR support side of the business. I also represent clients at Employment Tribunal, and it's a well publicised area of case law that I'll be concentrating on today. The correct basis for calculating an employee's entitlement to holiday pay has been doing the rounds in courts at various levels for the best part of 5 years now. To start with, it's worthwhile recapping on the background to the current uncertainty in this area, both from a legislative and a case law point of view. As far as the relevant case law is concerned, this can be traced back to the 2010 case of Williams versus British Airways, in which pilots argued that they should have been paid flight time supplements whilst on holiday. Upon referral to the Supreme Court, the European Court of Justice considered the provisions of the Working Time Directive, which is the European law that the UK has to work to. The Working Time Directive is a European directive which was incepted in 1993 by the Council of the EU. Like all EU directives, it's an instrument which required member states to enact its provisions in national legislation. At the time, the UK strongly opposed the element of the directive which limited the working week to 48 hours, and managed to negotiate a UK-specific provision whereby workers could opt out of the 48-hour working week and work longer hours. However, it's not possible to opt out of the directive's other requirements, one of which is that EU workers receive at least 4 weeks paid leave each year. The directive was implemented in the UK via the 1998 Working Time Regulations, and these regulations state that statutory annual leave should be calculated via the method provided for in the Employment Rights Act 1996, so that staff working normal hours, where overtime is not guaranteed, are only entitled to receive their basic salary, without any additional overtime, bonus or commission payments being incorporated. In the Williams case, the Supreme Court decided that the provisions of the Working Time Directive were such that workers taking statutory holiday should receive their normal remuneration, including any payments intrinsically linked to the performance of contractual duties. Then in 2012, an employment tribunal determined in the case of Neal versus Freightliner Limited that payment received by a worker during a period of voluntary overtime should be reflected in the pay they received during a subsequent period of statutory annual leave. This was on the basis that he performed tasks required under his contract during that period of overtime, meaning the aforementioned intrinsic link was present. This was closely followed by the cases that have just been decided on appeal by the EAT, those being Wood and Others versus Hurtle UK Limited, Fulton and Another versus Bear Scotland Limited, and Law and Others versus AMEC Group Limited, in which the initial tribunal decisions stated that compulsory overtime and incentive bonuses should be taken into account, and the calculation of holiday pay should be based on a 12-week average of actual take-home pay. Then in 2014 came the ECJ's preliminary ruling in the case of Locke versus British Gas Trading Limited, where the Advocate General, who's a lawyer that advises the court on a neutral basis, issued an opinion to the effect that holiday pay should also include commission, where it's directly linked to the performance of contractual tasks and it has a certain degree of permanence. In the midst of these snowballing decisions in favour of the employee, there was some light relief for employers in the case of Elms versus Balfour Beatty, where the tribunal held that overtime should not be factored into holiday pay and that it should only be calculated with reference to basic pay. But alas, that case settled before it reached the EAT, meaning that we were left awaiting the EAT's verdict on the employer appeals in the Wood, Fulton and Law cases, and also the tribunal's eventual decision on Locke. In terms of the latest position, the EAT appeals were heard at the end of July and beginning of August, but the judgment was reserved. Around the same time, Unite and Unison sent information packs to their members and produced pro forma letters for them to send to their employers, referring to the recent cases and requesting relevant information relating to their holiday pay arrangements. Then on the 4th of November 2014, the decision in Wood, Fulton and Law was published. In it, the EAT ruled that non-guaranteed overtime, which is overtime which the employer does not have to provide, but which the worker must undertake if requested to do so, should be factored into holiday pay. The EAT determined that the non-guaranteed overtime payments in question in these appeals had an intrinsic link to the performance of contractual duties to the extent that they form part of normal remuneration, and therefore that they must be taken into account under the Working Time Directive when calculating holiday pay in respect of the 4-week minimum EU entitlement. Important to note here that these decisions don't apply to the additional 1.6 weeks leave provided under the Working Time Regulations, or any contractual holiday that employers may provide in excess of that. One of the biggest fears for employers in respect of these cases is that some of the decisions to date appear to have given rise to the possibility that workers could make retrospective claims for historical underpayment stretching as far back as the implementation of the Working Time Regulations in 1998. However, the judgment does appear to have limited the scope for these by stating that they would be time barred where there has been a break of at least 3 months between successive underpayments. This, the EAT say, is because a gap of more than 3 months means there can be no series of deductions from holiday pay, and therefore tribunals will not have jurisdiction to hear such claims. So, some good news and some bad as far as employers are concerned. However, there may yet be appeals from either the employers or the employees involved in the recent EAT decision, possibly even both. Therefore, we're still in a situation where the calculation of holiday pay has yet to be unequivocally clarified. For this reason, our advice to clients is broadly the same as it's been for the last 6 months or so, which is that there are, as we see it, 2 main options open to them as employers. They can either take steps to mitigate past liabilities and reduce future liabilities by introducing changes to holiday pay that reflects the general thrust of the relevant decisions to date. This would involve factoring in all elements of normal pay such as overtime and commission into the calculation. The legal argument here would be that this breaks the series of supposedly unlawful deductions and would mean that employees only have 3 months from the date of the change to bring their claims. However, it's important to bear in mind that the success of this strategy isn't guaranteed, on the basis that tribunals may determine that it wasn't reasonably practicable to bring claims in time, perhaps on the basis that the legal position was uncertain at the time that the deductions in question were made. The second option is to wait and see whether any appeal is lodged within the 42-day timescale applicable to the recent EAT decision. To await the outcome of the Locke case, which is scheduled to be heard in February 2015, and also to wait and see whether the government acts upon the widespread calls from employers to introduce emergency legislation to limit the impact of the rulings to date. Whichever route you choose to take, it would be advisable in the first instance to review your existing method of calculating holiday pay and assess your potential liability. It may also be worth considering establishing a fund in this regard if your business can afford the luxury of doing so. In terms of what response should be provided to staff or unions who ask challenging questions in relation to the holiday pay issue, this will depend on the nature of the enquiry and the general tack the organisation has decided to adopt. And as there's no one-size-fits-all guidance here, we'd strongly urge you to contact us for advice that we can then tailor to your own circumstances. And that concludes this podcast, which I hope has gone some way to clarifying the current situation surrounding holiday pay. If you require more bespoke advice on this matter, or any other employment law related topic, then do please get in touch with us using these contact details. Thanks for tuning in, and bye for now.